Thanks, Annette, and I'm very happy to be here today. So today's discussion is going to be on how business executives can avoid a data security disaster. And we're going to be talking about business, not about any particular technologies or tools or services, but just generally what a business executive needs to know about security and what they need to do. So before I start, let me give you a little bit of history of my background. I've been in the IT business for over 35 years, and I started out owning a company that provided IT services to clients. When HIPAA came out in 2003, I got very excited that the federal government was going to regulate the entire healthcare industry. When I say I got excited, I thought that was a big opportunity for me, so I went and I got some HIPAA certifications and went to market as a HIPAA specialist. I was asked by a local hospital to become their chief information officer, and I actually turned them down and said, if you want me, you can hire my business. So that's what they did. They hired my company and got me as the CIO and got my techs and engineers to work with their IT department. I did that for a couple of years, and we built a HIPAA compliance program and a cybersecurity program from scratch with very little guidance. HIPAA was new, the security rule was new, cybersecurity did not have the maturity that it certainly has today, so it was a big challenge. I then, through another relationship with a friend of mine who was in business in Nevada, became the chief information officer for a K-12 school district. And the K-12 school district did not have to comply with HIPAA. It had to comply with FERPA, which is a law that protects student information, and they had some other compliance challenges as well. But we didn't have good guidance through FERPA about how to protect data, so I took the HIPAA security rule and applied it to a school district, and it worked. We took the requirements or the recommendations to protect data and simply applied it to student data instead of medical records, and it gave us the security that we needed. And that was a big message to me in the sense that if you have a good security framework, you can apply it to anything. There still may be some additional compliance requirements based on the particular regulations, but you do have the protection of the data, which is what these regulations are about to start with. You'll see that I've got a lot of certifications, and I believe in certifications, and some of the certifications are specific to HIPAA and healthcare, but I'm also a certified security compliance specialist and also a certified business continuity professional through the Disaster Recovery Institute. In addition to consulting with businesses, I do a lot of speaking and writing. And the Healthcare Business Monthly article just appeared in January 2017 in the most recent edition. I was fortunate enough in 2016 to be invited to the Kennedy Space Center to speak to the NASA Health Organization. And I recently pre-published a book on Amazon about HIPAA, and even though it's pre-published and not available for delivery yet, it became a #1 bestseller in several Amazon categories. In addition to cybersecurity and compliance, our company also does business continuity planning, and we do two things. One is that we audit existing plans. We have clients that bring us their plans and ask us to be an independent auditor to determine if the plans will work. We also create plans that work. And when I say plans, they go beyond just the IT. A lot of businesses think their business continuity plan needs to just be their IT recovery plan. And while IT is important and certainly critical to a business, there are a lot of other things that need to be dealt with in terms of personnel, communications, facilities, and so forth. Even though we do a lot of work in the healthcare industry, one of our largest clients was a federal credit union that had to comply with NCUA, the National Credit Union Administration requirements for business continuity planning. So not only did we come up with a plan that met those requirements, it also worked, and they were able to survive Hurricane Sandy or Superstorm Sandy. We had a client in the Midwest, Heartland Technology Solutions, that is in 5 states in the Midwest. We did their business continuity plan, and just 2 weeks after the plan was completed, Joplin, Missouri was hit by the tornado. Their business was not directly hit by the tornado, but it was just up the street, and they were severely affected by that, and they used our plan to survive the Joplin tornado. So for today's discussion, when we say security and we talk to people, they have all these different pictures in their minds. And the picture will vary based on what your job is and what your role is when it comes to cybersecurity. But I'm going to use a very simple definition when we talk about security, and that's simply the protection of data against loss, theft, or unauthorized access. We're not talking about any particular type of tool. We're not talking about any particular service, just generally the protection of data against loss, theft, or unauthorized access. And this is the terminology that I use when I talk to the business managers in the organizations where I worked, where it was the hospital where I had to deal with senior management and the board of directors. I also had to work with the school district and all the department heads, the superintendent, and the publicly elected school board. So we made it very simple for them to understand what security was without getting into any particular product, services, or technology speak. How I approach security is very simple. Security is a business problem with a technical solution. It's not a technical problem. For the business, it's a business problem, and it has to be put in business terms and quantified so that the decision makers, whether they're executives, whether they're a board of directors, or simply a business owner, has to make a financial decision at some point to allocate the appropriate resources for cybersecurity and for compliance. So it becomes a business problem to them, and I had to convert whatever I needed to do technically into business talk and a business problem that they understood so that they could give me the resources that I need. Our definition of compliance is very simple, but when we talk about compliance, everybody thinks about regulations. Our definition of compliance is simple. It's having to meet requirements set by others. And when it comes to regulations, they're on the list, but there are other things as well. So when we look at governmental regulations, we first of all have federal and state laws. So we have HIPAA for healthcare, GLBA for finance, the FFIEC if you're a bank, Securities and Exchange Commission. I won't go through all of them, but the idea is that if you're in an industry, you probably know what the general regulations are that you have to follow. In the school district, we got funding through the federal E-rate program. So even though everyone knew that we had to protect our student information under FERPA, we had additional requirements because we were getting funding from a particular source. We have state data breach laws, and then government agency and vendor requirements. For example, if you're a government agency, there may be specific rules and regulations that you have to follow to provide a certain level of security. And if you want to do business with a government agency, for example, if you're a defense contractor and you want to work with the Department of Defense or one of the armed forces, there are requirements that you have to secure information. There are also industry requirements. If you take credit cards, you have to comply with PCI DSS. PCI stands for the payment card industry. DSS is data security standard. But this is not a federal regulation. It's not enforced by a government agency. It's enforced by the credit card companies through the Payment Card Industry Association. You also have bar association requirements for lawyers. And these are ethical requirements. Again, they're not enforced by law enforcement or the state government or the federal government. They're enforced by the State Bar Association that licenses attorneys. Insurance companies. You don't think of this typically when we talk about compliance, but when you fill out an application to buy cyber liability insurance, you're answering questions that may come back and haunt you later. We're going to talk about that in one of our examples today. But insurance companies have requirements on the applications, and the applications themselves are required, and you have to be truthful and accurate on them. More and more, we're seeing requirements from either clients or business partners that work with your organization with information that's buried in contracts. And I'm talking specifically about cybersecurity requirements that are in contracts, not just what's required by the federal government or even an industry requirement, but what the organization that is signing the contract with you requires you to do to secure the data or the information they're providing you with under contractual obligation, not just the law. When it comes to regulations, some of them are prescriptive. They tell you what to do. For example, the HIPAA security rule has about 50 items on it that are things you have to do to protect data, and they can audit you against those 50 things. We also have many data breach reporting requirements that are reactive. They don't tell you what to do to protect data. They tell you what you have to do in the event of a breach. So they're reactive. They tell you, here's what you have to do to notify the government or notify consumers or notify patients, but they don't tell you things that you should have done to protect the data. So one of the questions we get a lot is, so what is protected? So what's protected by regulations under state laws are what they call PII, personally identifiable information. And 47 states, with the exception of Alabama, New Mexico, and South Dakota, all the other states require that Social Security numbers are protected under their state data breach laws. Same thing with driver's license numbers and banking information. So let's look at Social Security numbers for a minute. What businesses have Social Security numbers? Well, every business does in the United States if you have employees, because you have to report the information on what you're paying them. So when we talk to people about Social Security numbers, they will automatically think it's the information that's contained in HR, which it is, but it's also in other places as well. Social Security numbers for contractors, for people that do work for you but are not your employees, are also in accounts payable because they're paid as contractors. They're not paid through the payroll system. So we have had organizations that have not realized that they have a lot of Social Security numbers in accounts payable, and we work with them to secure those. Driver's license numbers are protected. Doctors' offices have driver's license numbers because when you come in as a patient, they'll ask for your insurance card and your driver's license number. You also have organizations that have fleets of vehicles, or if somebody's going to drive their personal car on business, your company may have the driver's license numbers. And where would those things be? They may be in HR, they may be in someone that handles risk management, but did you even know that driver's license numbers are protected? Protected health information, PHI, is protected not just under HIPAA, but the Federal Trade Commission looks at the people whose protected health information was breached as consumers, not just as medical patients. So the Federal Trade Commission has penalized organizations when they've lost health records. Personal financial information is protected under a federal law called GLBA, or the Gramm-Leach-Bliley Act, and also the Federal Trade Commission has weighed in on organizations that have not properly protected personal financial information that has been breached. The Federal Trade Commission can issue fines, but they have also put a lot of businesses on 20-year monitored compliance programs, 20 years, where you have to report your compliance and be audited, and that's very expensive and very difficult to do. Credit card transactions, as I said a few minutes ago, are protected under PCI DSS, and student records are protected under FERPA. If you're a lawyer and work for a law firm, attorney-client communications is protected under ethics requirements. These are not laws. These are not things where the Federal Trade Commission may come after you. But if there's a data breach of client information, it can go to the state bar and be enforced as an ethics violation. More and more we're seeing contractual requirements. So in Arizona, the Maricopa County Community College put out a bid for legal services. They were looking for a new law firm, and in the bid they had 9 pages of cybersecurity requirements just if you wanted to be their law firm. We have some clients that do business with the Mayo Clinic. The Mayo Clinic has a basic HIPAA business associate agreement like many healthcare organizations, but they have added to it a 4-page cybersecurity addendum. And the thing about this is that we have found this information filed with the business associate agreements, and our clients that have signed the business associate agreement with the Mayo Clinic did not know or had not paid attention to the 4-page addendum that had the requirements for cybersecurity. So if they had had a violation, it wouldn't have just been a HIPAA violation, but it could have been a breach of contract with the Mayo Clinic if all the things that were on that list were not had not been handled. So someone signed the contract and actually filed it away, and we asked them to pull it out, and we read to them what those requirements were in the contract that they had already signed, and they were not in compliance with the contract. We were working with a health plan, and the health plan told us that they didn't have any specific cybersecurity requirements with an organization that they wanted to do business with. Actually, we were working with a vendor that wanted to do business with the health plan. We looked at the contract, and the contract said that the supplier shall have at the effective date and shall maintain for the duration of this engagement a HITRUST CSF certification. That's an industry certification in healthcare for IT cybersecurity. The guide to the HITRUST certification was 112 pages. So this one little line in the contract, which had been missed by our client, by the way, had 112 pages of cybersecurity guidance attached to it. So these are the types of things we're seeing in contracts that are not necessarily covered by any federal regulation, but are in the business contract that an organization signs with another organization. And the penalty, again, under a contract, is a breach of contract lawsuit. And that's completely different and actually much more likely to happen than, for example, a federal investigation into a data breach. Here's another example. We see data use agreements from organizations which are separate from the contracts that people are signing to do business with them. So this is a data use agreement through the State of Texas Health and Human Services Department, where doctors and other types of organizations that provide healthcare services go to get Medicaid eligibility information. So under the breach notice section of this contract, it says for federal information including without limitation, tax information, Social Security Administration data, which would be Social Security numbers, and Medicaid client information, which is typically why people are going to this database. It says within the first consecutive clock hour of discovery, the breach has to be reported to the State of Texas Department of Health and Human Services within one consecutive clock hour, 7 days a week, 24 hours a day. This organization that had signed this and showed it to us thought that their reporting requirement was based on HIPAA, which gives you 60 days to report an incident to the federal government. But in this case, they had signed an agreement for 1 hour to the state. So we worked with them to change their data breach reporting requirements and their data breach reporting plan based on the type of data and where it came from. If it was information just covered by HIPAA, they had up to 60 days to report it. But if it was anything that came from the state, they had 1 hour, 7 days a week, 24 hours a day to notify the state that they may have had a breach, because at 1 hour, there's not much information you have when you're starting an investigation. Here's an example of a company, Omnicell, that lost a laptop and what the effect was. So Omnicell provides drug carts to hospitals. These are big carts that the nurses push down the hall, and they have medication in them and a computer built in. So when a nurse gets to a patient's room, they enter the patient's name, a drawer pops open with the patient's medication, they give the patient the pills, and then when they come back and close out that transaction, it updates the inventory for the pharmacy, so the pharmacy knows to order more pills. It also updates all the patient billing information and so forth. So Omnicell was having a problem with its software, and they sent a technician out to 3 large healthcare systems to try to fix the problem. He brought his laptop with him. He downloaded 68,000 patient records, and then his laptop was stolen out of his car. If you went back to Omnicell's contract with these healthcare systems, it said that data would only be stored on encrypted devices. This computer that had been stolen was not encrypted. So the customers, the 3 healthcare systems, each called press conferences and positioned themselves as victims of Omnicell and said that Omnicell had breached the contract that they had signed. So when you look at this, this is not just a HIPAA data breach, because 68,000 patient records had to be reported as missing to the federal government. Now these organizations were suing Omnicell for breach of contract. My question is very simple. The people that signed the contracts were probably executives in these organizations. Did Omnicell executives communicate its contractual requirements? In other words, did they tell anybody what they had signed? Did they tell purchasing, when you buy a computer for a field technician, make sure you order encryption? Did they tell IT, when you deploy computers to field techs, make sure they have encryption? Did they tell the field techs, you are not allowed to store information on a device that's not encrypted? And by the way, your computer's not encrypted. Did the tech that stored those 68,000 records have any idea he was doing something wrong, or was that contract signed by the executives and then just stuck in a file folder in a cabinet? But there's another side to this. These hospitals that positioned themselves as victims of a breach of contract were also party to the contract. Did they do anything to validate or to audit that the contract was being complied with? So did they do anything to go back to Omnicell before the breach and say, can you please prove to us that the laptops your techs are carrying are encrypted? So I think they had some skin in the game. They did position themselves as victims and went after Omnicell for breach of contract. But it just makes me wonder why they signed something and also stuck it in a file folder in a cabinet and did nothing to make sure that the vendor, in this case, was living up to their agreement. Here's an insurance case that happened out in California, and it was a $4.1 million cyber liability insurance lawsuit. And this was an insurance company suing its own client to get the money back. So here's what happened. Columbia Casualty, the insurer, sold a cyber liability or data breach policy to Cottage Health, which is a healthcare provider. Cottage Health hired an IT company that accidentally published patient information to the internet. So when the patients were out Googling themselves, they were getting back their medical records. So when this happened, it was discovered, it was reported, and Cottage Health was sued by the patients. And they went to Columbia Casualty and said, as part of the policy, you're supposed to defend us. So Columbia Casualty provided them with a legal defense, and the attorneys negotiated a settlement with the patients of $4.1 million. Then Cottage Health was told by Columbia Casualty that the insurance company was still reserving its rights under their contract and investigating the situation. This is even as the $4.1 million was being paid out to the patients. So afterwards, Columbia Casualty discovered that Cottage Health was not accurate on its insurance application, and Cottage Health was being sued by Columbia Casualty to get the $4.1 million back. And here's what the lawsuit said. It said that Cottage Health's application for coverage under the Columbia policy, quote, contains misrepresentations and or omissions of material facts that were made negligently or with intent to deceive concerning Cottage's data breach risk controls. So what this is saying is that whether maliciously or just because they did it without any intent to deceive, in other words, somebody just made a mistake, the insurance application wasn't accurate when it came to the data breach security controls. We have seen this with our own clients. We had a client that told us when we first went for their site visit that their laptops that contained some information that was regulated were not encrypted. And this was just the course of conversation throughout the day, that one of the things they needed to do was encrypt their laptop. At the end of the day, we were done with the compliance discussion. We had done the walk around for the security audit and so forth. And I asked them to show me their cyber liability insurance application. They had told us they had the insurance, and I asked to see the application. On the application, there was a question, do you encrypt your laptops? And the answer was checked off, yes. So I asked the person who brought the application to me if I could talk to the person that filled it out, and she said I did. And I said, well, you told me first thing when we started this conversation with you that your laptops weren't encrypted, but you answered the question here that they were. Why did you answer the question this way? And she said, I don't know. And this is something where if she had lost, or if her organization had lost an unencrypted laptop, it was the loophole that the insurance company would be looking for to not have to pay the claim. So They ended up encrypting their laptops. We didn't go back and tell the insurance company the application was wrong. But the message here is that if you buy cyber liability insurance, you don't necessarily have the confidence that it's going to pay off, because if you weren't accurate in your insurance application, they can use that as a reason for not paying. And what's the effect in this case? Not only was Cottage Health out the premium that it paid for its insurance, their insurance company was charging them back for the $4.1 million and the legal fees that they felt they paid incorrectly. Here's a business example of a company that lost a laptop, and the financial effect on the company was $668 million. How do I calculate this? If you look at the chart below, this is the chart from 2011 to 2016. 2011 was before the laptop was stolen, and the stock was worth $33.15 a share, and the market capitalization, the value of the company, was $865.7 million. In 2012, they lost the laptop. In July of 2012, they settled with the Minnesota Attorney General not to do business in the state for between 2 and 6 years. In 2013, the chief executive officer was replaced by their board of directors. And later on, the next month, the CFO, chief financial officer, was fired by the board of directors and replaced. In September of 2013, about a year after the laptop was lost, there was a $14 million class action suit by investors, not by the patients whose information was in that laptop, but by the investors who felt that the company was not doing what it should do to protect data. In December of 2013, the Federal Trade Commission settled with the organization and put it on a 20-year monitored compliance program. In 2016, their client, the hospital that hired them, was fined $1.5 million because of what their vendor had done. And in July 2016, the company was still going, but it had been delisted from the New York Stock Exchange, and the value of the stock had gone from $33 down to $1.95. So the market cap value of the company went from $865 million down to $197 million, which was a loss of $668 million in value that can be tied back to the loss of a laptop. Verizon announced last year that it was going to acquire Yahoo, and then Yahoo announced a data breach, and then Yahoo announced another data breach. So this is a headline from Investors Business Daily, again, telling investors who are involved in owning the stock of these companies or looking to purchase it, that Yahoo disclosed a new, bigger data breach, and Verizon may scrap the purchase. Then it came out in another headline from October of 2016 that Verizon wants a $1 billion discount on the Yahoo deal after reports of hacking and spying. So this is a data breach, or two data breaches, or the failure of IT security to properly work, that is a $1 billion with a B effect on a company. So what's the first question after a data breach? Often it is, how did our IT department screw up to cause this to happen? The IT department always gets blamed for this. So that's very often what the executives are asking. And then what's the next thing to happen? They're going to use the IT department or the CISO or the CSO, Chief Security Officer, as the scapegoat and blame them for what happened that caused the data breach. But it's not always fair, because sometimes it's because corporate management made decisions or didn't make the right decisions to properly support the requests and the requirements of the IT and the security departments. At what point in your organization will the CEO and the board get involved? It's not something that a CEO or board should just task out to a compliance officer or a security officer or a CIO and expect that it's going to be done. They have to take an active role. And the problem is, at the time that they end up taking an active role may be after a big breach. So you look at these headlines, 40 million target customers were affected by a data breach. That obviously shot to the top, shot to the executive suite, And not only the chief executive officers, but the board of directors had to get involved because it was such a big deal. This information that came from Bloomberg says that Target and Home Depot each estimated that their data breaches resulted in about $200 million in expenses not covered by insurance. So there's some dollar amount in your company, and it may not be very high, where the chief executive officers and the board of directors will get involved if there's a breach. And my message is very simply, it's better to happen before the breach occurred. Advocate Healthcare in Chicago paid a $5.5 million HIPAA settlement, which was the record, the highest HIPAA settlement ever. And again, at what point did the board and the CEOs get involved in this discussion, and should they have been involved sooner to protect the data and have avoided the breach to start with? Many times people in organizations think that their data is in official systems or in databases. In a hospital, it would be the patient care system. In a bank, it would be the system that stores all the information about bank accounts and things. But what we find in organizations is that information that's protected is all over the place. We find it now on mobile devices. We find information left in voicemails, which are now really computer files that may get attached to an email and so forth, or be accessible through a portal. We find people putting data on thumb drives and other portable devices. There's a picture of a person working for an answering service here, and the message to there is that it's somebody outside your organization that you may have contracted with as a vendor to have access to your patient records or your client records or customer records, but they're a third party. And then up in the corner, it talks about the cloud. There are many, many types of cloud services out there, and some are appropriate and are secure for storing protected data and information that your organization simply wants to keep secret and secure. But then there are others, particularly consumer-grade products, that are not appropriate, but it's very easy for someone to set up an account or to store information on one of these systems. So if you look at the picture of the cell phone, an example that we found recently was that the people that worked for an organization used personally owned telephones. One of them had an iPhone that had very sensitive data on it in their email, and they had set up their iPhone to automatically back up to iCloud. So they're the consumer as far as iCloud is concerned, not the organization whose email they have on their system. So if they were terminated from that organization, all the company mail that may have been deleted off their phone was still available to them through iCloud. So this is just an example of where data is leaking out of organizations and some of the things that we find when we do our assessments. Data is worth more than gold, and I'm going to prove it to you very simply. A thumb drive weighs 3/4 of an ounce. Gold right now is a little bit above $1,200 per ounce. So if a thumb drive was made of solid gold, it would be worth about $900. This is an example of a life insurance company that filed a breach report that a USB data storage device, which they called a pen drive, basically it was a thumb drive, containing EPHI, electronic protected health information, was stolen from its IT department, where the device was left without safeguard overnight. And then down below it says the report noted that the breach affected 2,209 individuals. So this was a little thumb drive that resulted in a $2.2 million HIPAA penalty. Remember, that drive, if it had been solid gold, would have been worth about $900. Because of the data on it, there was a $2.2 million fine, which divided out translates out to $1,000 per patient record on this little thumb drive. So the data on that thumb drive was worth more than if that thumb drive had been made of solid gold. Here's a source of information that can also be used to quantify the cost of a data breach. So a company called the Ponemon Institute, it's a research organization, was hired by IBM to study the cost of a data breach and released this report in 2016 for breaches that occurred in 2015. And they contacted the companies that had had breaches and calculated what the effect on those companies were. So when you look at these numbers, think about this as an iceberg. And above the waterline, the iceberg that's showing is the actual cost of the breach itself, and below the waterline is the financial effect on the business. So for all industries, retail, hospitality, healthcare, just all the industries blended together, the cost of a data breach in this report was $221 per record. However, for healthcare specifically, the cost was $402 per record. So I've done some math for you at the bottom that says if you have 10,000 records, so that could be patient records in a healthcare system, it could be customer records if you're a business, or credit card numbers, that the effect on the business would be $2 to $4 million if that information was lost or accessed without authorization. If you have 25,000 records, and we find those numbers even at small doctors and small communities, that they've had 25,000 patients throughout the years, and they're in their electronic health record system, $5.5 to $10 million, and 100,000 records could be as high as $22 to $40 million. Now, we have run these numbers by some clients, and they said, oh, it wouldn't cost us, $4 million if we lost 10,000 records, or $40 million if we lost 100,000 records. And our answer is simple. Okay, take 50% of that number, 75% of that number off. So if it's 100,000 records, instead of costing $40 million, maybe it only costs you 10. Maybe you get a 75% discount. What it really gets down to is not to just use these numbers as if they're going to be accurate for your business, but use them as the idea that this information has been done through research or has been collected through research, and you have to come up with a number because you have to be able to identify what your risk is. So one of my challenges when I was the CIO in a hospital and also in a school district was always getting the adequate resources that I needed to properly secure our data and protect our clients or our patients in the hospital or the students in our school district. So you probably didn't expect to see a picture of a horse in an IT security discussion, but there's some simple concepts here. It's not smart business to protect a $100 horse with a $10 fence. It's also not smart business to protect a $10 horse with a $100 fence. So what's the message here? The message is simple. What is your horse worth? So applying this to cybersecurity, what's the value of the data that you're protecting? And it's not necessarily the value of the data itself. What would be the impact on your organization if you had a data breach or if you were hacked? So what are some tools you can use to quantify the risks? If you want to use the Ponemon report and the number of $221 or $402 per record, you have to know how many records you're protecting. And it surprises me, but we've had many clients who could not answer that question. How many records are in your system? So one of the things we've done is to educate them to try to identify how many records they're storing and what the cost per record might be if there was a data breach. You can also look at fines. I just showed you an example of a lost thumb drive that resulted in a $2.2 million fine. So this is real. This is information that's released by the federal government. It's all verifiable. And if you're talking to your management about protecting devices so that a user can't plug a thumb drive in and download information to it, even though we all think that's convenient, maybe the executives like the idea that they can do that and take work home, you can show them that someone just paid $2.2 million for a lost thumb drive. There had been a previous penalty for a lost thumb drive of $150,000. So the question becomes, what's the price of convenience for that? And you can use fines that other people have paid as the source of information. You can estimate what the legal fees would be if you had a data breach investigation or if you had to defend a lawsuit. You have to pay for forensic services after a data breach. What are the PR costs, public relations costs after a data breach to help protect your reputation in the marketplace? In some states, you have to pay for credit monitoring for the victims. So if you knew how many records you're protecting, instead of using something like the Ponemon report, you could simply say, credit monitoring for each one of those people would be $100 per year, and we have 10,000 records or 25,000 records in our system. That's an easy way to do the math. What's the effect on your reputation, and how much business would you lose? And you may lose current clients, but if you've got a big proposal due next week or next month with a potential client, and then your name's in the newspaper for having a data breach or losing a thumb drive and getting penalized $2 million, you could just have the value of that contract at stake. What would be the cost of data breach reporting, protecting against lawsuits or defending against lawsuits? People may say, well, we have insurance for that. Well, I've given you an example where insurance didn't pay off. So what would be the risk to your organization if the insurance that you thought was going to cover you didn't cover you? And then the bottom line, like we showed you with Accretive, is how does this affect the company market value? So here's some things that we see during our assessments, and some of these may surprise you. We were working with a client whose network administrator told us we have security handled, and there was a lot of attitude in that statement. We ran a scan on their network and identified risks that were at 100 out of the possible score of 100 using this system. We had sent a questionnaire to the client that said, how frequently must passwords be changed? And they entered in every 90 days. We asked another question down below, list any users exempt from password rules, and they said no one. So everyone's password, according to him, expired every 90 days. We ran scans on their network, and you can see that passwords are set to never expire. Now, I whited out the names, but the person's name that I highlighted there was the person who was telling us the passwords were set to never expire. We ended up talking to the senior executive at that organization and showed them this information, and the lady said to me, I believed him, and I thought that our passwords were set to never expire, or that were set to expire every 90 days. And I asked her, well, if that was the case, do you get a message every 90 days to reset your password? She thought about it for a minute and said, no, I don't. The bottom line was, these people had believed, because they had written policies that said passwords are set to expire every 90 days, that they were actually doing it when they weren't. Further on in the questionnaire, we asked about patches and updates, security patches and updates for their computers and servers. And it said that patches are all installed on all their computers and servers, and that patching is done automatically by a system. This is from their report, that we found that on one of their key servers, it was missing 104 security patches. I went back through Microsoft's database of security patches and counted back 104 and found out that that server had not been patched in over a year, and they answered the question, and I'm sure he told his boss, yes, all of our servers are being patched, and it's done by this automatic system. 104 security updates were missing that went back over a year. Here's an organization where they missed the obvious. This is a health plan, and they were paying $20,000 per month to a service to monitor activity in its database and send alerts for unusual activity. $20,000 a month, roughly $250,000 a year. And we were doing a site visit, and I did a walkthrough with the CIO. And the CIO walked by this office every day. This is the user's computer that has 2 monitors attached. As you can see, the monitor on the left is actually the display that's being used. The monitor on the right is being used as a Post-it note stand for logins and passwords, not just into their network, but into a bunch of organizations that they had contracts with that gave them permission to access those databases. Everything was written on Post-it notes out on the screen. The message here is that when you look at this situation, don't just set your eyes on the things that can be protected by these shiny new objects or the shiny objects that we love to purchase, the appliances and the services and the software that offers cybersecurity capabilities. But if you're going to invest in that, don't forget to do what I call security by walking around, to make sure that your users aren't doing things that nullify all the investment you've put into good tools to protect your data. So here's some things that business executives can do to prevent expensive and embarrassing data breaches. This is the FBI's warning to healthcare organizations. And this warning said in 2014 that the biggest vulnerability to the security of patient data was the perception of IT healthcare professionals' beliefs that their current perimeter defenses and compliance strategies were working when clearly the data states otherwise. So the first thing is, if you're not a healthcare IT professional, this does still apply to you, because we found this is not unique to the healthcare industry. This cuts across all industries, that people believed that their perimeter defenses, their firewalls and different types of devices, intrusion prevention systems at the perimeters of their networks are working, and that their compliance strategies are also working. So the greatest vulnerability to data isn't a specific security problem, it's your belief that everything's working when maybe it isn't. So how do executives, or how should executives manage compliance? First of all, they shouldn't task it out. A CEO, CFO, whatever the top level executives are in an organization, should not just task out compliance to a compliance officer, or a security officer, or a CISO, and not understand what the risks are. Executives need to understand the business risks associated with regulations, understand the business risks, associated with cybersecurity. The executives are the ones that are typically signing those contracts that are getting folded or filed in file folders in cabinets. So the first thing is they need to pay attention to what they're signing. And the second thing is they need to communicate that information to other people in their organizations, where those folks have the hands-on requirements or the hands-on responsibilities to carry out what's in the contract. So going back to Omnicell and the contract that was signed and filed away, and the field tech was provided with an unencrypted laptop, if your executives are signing contracts that have cybersecurity requirements in them, they should share that information with you, and it should go all the way down the line to the people that are involved in the specific tasks associated with complying with those contracts. Executives should trust their staffs, but, and this is based on many years of experience that we've had doing assessments, you should verify with an independent security and compliance assessment what's really going on. Now, verify means somebody needs to get under the skin the same way a doctor would have you do a blood test or an MRI. If you come for an annual physical, you tell the doctor you're feeling fine, the doctor's still going to run a blood test and maybe put you through an MRI. They may find something, a dark spot on your liver or your kidney that you don't feel yet, which could end up killing you. But the idea is that they don't just take your word for something. They will verify through a third party, the people that are doing the MRIs and the blood tests, what's really going on with you. So the reason we think verification and validation is important is that it will either validate that your staff is doing the right things and your systems are working, or identify risks before they get out and become data breaches and million-dollar headlines. When we look at security and compliance, I try to picture it in a way that people understand that it's like a three-legged stool that can't stand unless all three legs are in place. So organizations always have policies, and people love policies. They have policies for their policies and policy manuals and all sorts of things that say what they're going to do. So one example would be, we're going to protect our devices against malicious software. That's a policy that an organization will have. Procedures document how you're going to do it. Procedures are really important, and very often they're not kept up to date, but they're important when there's a data breach or an investigation or some issue where someone wants to validate that the policy is being carried out. So a procedure for that policy that says we're going to protect our devices against malicious software would be that we're going to use a particular brand of antivirus software or a particular type of firewall, and we're going to train our employees and so forth. So that these are the procedures that we have in place. What's the third leg? If you have policies and procedures, then you need to produce evidence that substantiates that your procedures are being followed, which would show that your policies are being followed. So we look at this kind of backwards in the sense that we very seldom get good evidence when we're doing an assessment from a client or of a client. Very seldom are their procedures kept up to date with their policies, but they always have policies. So when we do assessments, and what senior management needs to validate is not only do we have the policies in place, but the procedures are properly documented, and that evidence actually exists to show that people are following through. These could be reports out of systems or calendar events or whatever. So what else is important? Well, I've already said this. Know the value of your horse. Using whatever process you think is reasonable and accurate, come up with what the risk is financially that you have to protect. If people question your number, work with them to come up with their number. But at some point, an organization has to have an idea of what its risks are in dollar figures for the executives and the board of directors to properly allocate resources to protect that information and secure it. Treat data like gold. When you picture a laptop, don't just picture a laptop with data on it. Picture a laptop that has solid gold in it. When you're thinking of a file server, don't think of just a rack of file servers or a standalone file server. Think of it as a vault that is loaded with gold. The file servers that centralize the storage of data are just like bank vaults. And when you look at this way, you'll realize you're not just a security or compliance expert. You are also like a banker or a bank security guard protecting very, very expensive, valuable assets. I'm going to close with this example that I used when I was working with our school district of how I tied technology, my technology request, to the business needs of the school district. So our school district received about $1 million in funding through the federal E-rate program. It's not very clear, but E-rate requires that we comply with the Children's Internet Protection Act. It's called CIPA. And CIPA compliance required us to replace about $50,000 in new firewalls. So I went to the CFO, who I affectionately called the CF No, because every time I asked him for money, he said no. He said it wasn't budgeted, it couldn't be allocated, it would have to go into next year's budget. I said to him we couldn't wait because we could lose that E-rate money. So I simply went to the school board, and in a public school board meeting, I connected the dots for it. I simply said, to protect our $1 million in E-rate funding, we only need to spend $50,000 on firewalls. And they immediately voted to purchase the firewalls. Now, the school district was made up of non-technical people, uneducated people. It was a school board, and a school board is elected by popularity. So we had people like hairdressers and car mechanics and other folks on the school board that didn't understand cybersecurity. But when I turned it into dollars and told them that to protect our $1 million E-rate funding, we only need to spend $50,000 on firewalls, they got it and they approved it. That's how I was able to take the technical information and boil it down into financial information they could act on. So at this point, I'm open for questions. I thank all of you for participating today. And at this point, please let me know if there are any questions. Thanks very much.